Welcome, everyone, and thank you very much for being here today. My name is Mohamed Darwish, the founding partner of Darwish Legal Consultants. Darwish Legal Consultants is a UAE based legal consultancy firm specializing in hospitality, real estate, and corporate law. We advise hotel owners and operators, real estate developers, and corporate groups across the Emirates on complex contractual and regulatory matters. Our team has handled some of the most challenging owner operator disputes, commercial agreements such as hotel management agreement, franchise, and lease agreements, and also corporate restructurings in the region. We are recording this presentation today because we genuinely believe that the issues we are about to discuss affect a significant number of our clients across the industry. So, whether you are a hotel owner or operator trying to manage a difficult management agreement, a real estate developer dealing with rising construction costs, or a corporate operator facing changing market conditions, this content is intended to give you a practical legal insight that you can act on immediately. This recording may take around 20 minutes of your time, but I can assure you it's time well spent because by the end you will have a clear understanding of your legal options and concrete actual plan to act on immediately. Stay tuned. So let me walk you through the roadmap for today. First, we will start by understanding the challenge itself, which is really the gap between what your contract says on paper and what the market reality looks like today. Then we will explore the legal tools available under UAE law, including force majeure and the very powerful Article 249 of the Civil Code. After that, we will walk through the real pressure points, things like fees, KPIs, employment, and supply chains. And finally, we will finish with practical solutions and an action plan that you can take back to your boardroom. Let me start by painting a picture because I think this will feel familiar to many people listening. Imagine that you signed a hotel management agreement 3 years ago based on a projected occupancy of 80% and a booming tourism market. At the same time, the numbers worked, the assumptions made sense, and the deal looked commercially sound. But today, your costs have climbed by 25%, your revenue is under pressure, and your contract still requires some fixed fees and performance commitments. This is exactly what we are seeing across the UAE, from serviced apartments in Abu Dhabi to boutique hotels in Ras Al Khaimah. So the contract is still binding, yes, but the business itself has fundamentally changed. Naturally, this leads to the big question that every owner asks. Can I claim force majeure? Or should we suspend, adjust, renegotiate? Let me give you a reliable example. A real estate developer in Dubai Marina, whose hotel project was delayed due to unexpected market shifts, might immediately think that force majeure is the answer. But as we will see, the law actually offers a more nuanced path, and in many cases, a more helpful one as well. So let us look at this carefully. Under UAE law, force majeure requires absolute impossibility of performance. In other words, performance must become impossible, not just difficult or expensive, it's impossible. Think of it this way, if a hotel was physically destroyed by a natural disaster, that would be a classic example of force majeure. But if your resort is still open, your staff are still working, and guests are still checking in, even if there are fewer of them, then that's not impossibility. The same principle applies in other sectors as well. For example, a corporate office lease in the IFC, where the tenant can still occupy the space, but simply finds it financially burdensome wouldn't qualify either. So the threshold is very high. So that's what is meant by impossibility. Impossibility, it means we are not able to perform due to a big disaster that happened. And here is the honest truth. Most of the situations we are seeing today in hospitality and real estate don't amount to force majeure. Your hotel is still operating, your retail tenants are still open, performance is still possible. It is simply harder, more expensive, and more commercially painful than before. As we often say in practice, this is burden, not impossibility. And that distinction is absolutely critical under UAE law. Now, this is where the real opportunity lies, and this is why this topic matters so much. Article 249 of the UAE Civil Code was designed for exactly this kind of situation. It says that if an unforeseen and exceptional event makes your obligations excessively burdensome, not impossible, but so heavy that they become crushing, then a court can step in and reduce those obligations to a reasonable level. Let me give you an example to make that easier to follow. A hospitality operator whose GOP has dropped by 60% because of the market wide disruption can ask a judge to rebalance the fee structure. In another example, a commercial landlord facing a tenant who can no longer sustain the original tenant can use this principle to adjust the lease. So the purpose here is not cancellation, the purpose is to rebalance. Let's make the distinction as clear as possible because this is really at the heart of the discussion. Force majeure means it's impossible to perform, and the result is usually termination or suspension of the entire contract. Article 249, on the other hand, means performance is still possible, but it has become unfairly burdensome, and the result here is judicial adjustment. Here's an example that helps people to understand and explain the difference. Think of a corporate joint venture where one party's costs have doubled due to new regulatory requirements. Force majeure will not apply because the venture can still operate, but Article 249 gives a court the power to adjust the financial terms. In hospitality, that can be the difference between shutting down entirely and staying open under more workable terms. Now, let us look at where contracts actually start to break down all that in practice. In my experience advising hotel owners across the UAE, the five main pressure points are fees, KPIs, pre opening costs, employment, and suppliers. And these are not theoretical issues, they are where the real tension usually sits. For example, a hotel owner in Jumeirah may be paying base management fees calculated on the gross revenue that no longer covers operating costs. Or a resort in Fujairah may be failing its RevPAR performance tests, not because the operator is performing badly, but because the entire market is down. These are the real battlegrounds. So let's start with fees, because this is usually one of the first things owners feel. In a typical hotel management agreement, base fees are tied to total gross revenue and incentive fees are tied to GOP. When the market shifts, these fees can quickly become a severe cash flow drain. I had a client, a hotel owner, whose base fees were consuming nearly all available cash flows during a downturn. So let me explain why this matters. Even when the hotel is still operating, the fee structure itself can become commercially unsustainable. So under Article 249, we argued that the fee burden had become excessive. And on Article 267, we negotiated the deferral of base fees by mutual consent, converting them into subordinated debt repayable from the future profits, and there's no courts was needed. The relationship was preserved and the business had a room to breathe. Reopening is one of the most contentious phases in any hospitality project, and many owners only realize that once problems begin. The operator controls hiring, procurement, and brand standards, but the owner on the other side pays for everything, including cost overruns and delays. I have seen cases where a hotel project in one of the finest places in UAE faced a 18-month construction delay. During that time, the owner was absorbing debt service costs while the operator continued charging the technical service fees. So this is not just a budgeting issue, it becomes a legal and strategic issue as well. So under Article 272, we use formal breach notices and cure periods to protect the owner's position. And under Article 271, we enforce development milestone clauses to make sure the pre-opening budget stayed within the agreed limits. The key lesson here is very important. You need to understand the difference between automatic cancellation and cancellation by notice. KPIs are another classic pressure point. The agreement may have been signed when the market was booming, with RevPAR targets of 100%, occupancy targets of 85%, and GOP targets of 35%. But today, the actual numbers may be closer to 65%, 50%, and 15%. Let me give you a real example. A hotel in Abu Dhabi was failing every performance test, but so was every comparable hotel in the same submarket. So hotel issue was not operator failure in the usual sense. It was market reality. So under Article 249, the court can reduce unrealistic KPI targets to reflect the actual market conditions. And Article 246, the principle of good faith, prevents an operator from insisting on metrics that no one in the market could realistically achieve. So again, you don't need impossibility here, you need reasonableness. Now, let me pause here for a moment because this is where things become very sensitive and very real. Employment is not just another coastline. For many of you, this becomes the biggest concern because your employees are not just staff, they are your asset. You have trained them, you have invested in them, you have built loyalty over years. And let me ask you something honestly. If you expect your guests to be loyal to your brand through loyalty programs, memberships, repeat business, how can you expect that if you are not loyal to your own people when things become difficult? This is where the conversation becomes more than legal, becomes strategic and even ethical. Now, let me be clear from the legal perspective. Under UAE Federal Law number 33 of 2021, you are allowed to terminate employees for legitimate reasons, including redundancy or restructuring. End of service benefits must be paid under Article 42, 45. WPS compliance is mandatory under Article 22, 58, and 65, and termination must follow lawful procedures, including notice periods and documented justification. So, yes, the law gives you the right to reduce workforce, but let me explain both sides clearly. The good side legally, you can reduce costs quickly. You can restructure your workforce. You can align staffing with current revenue. The risk, and this is important, you lose trained talent, you lose institutional knowledge, you risk damaging your brand culture. And when the market recovers, you start again from zero. So the real question is not just can we terminate? The real question is should we, and what extent to we have to do this? Because sometimes the smarter strategy is not removable, it's restructuring, reducing hours, adjusting roles, relocating teams, because loyalty is not something you demand, it is something you build up along the years, especially in difficult times. Your suppliers are under pressure as well, and that pressure flows directly into your operation. In the UAE hospitality and real estate sectors, we are seeing suppliers demand upfront payment, tighten credit terms, and prioritize cash paying clients. Let me give you several real examples because this one of the those areas where practical reality really helps explain the legal point. In one hospitality case, a five-star hotel was sourcing fresh food, linens, and cleaning suppliers from multiple vendors on 60-day terms. Credit terms, I mean. When the market shifted, those vendors reduced credit to 15 days and demanded partial prepayment. As a result, the hotel's monthly procurement bill increased by 30% purely because of cash flow timing, not because the goods themselves became more expensive. We sat down with the owner and the vendors together and negotiated consolidated supply agreements, bundling the food and beverage, housekeeping, and amenities under a single master procurement contract with staggered payment milestones tied to actual occupancy levels. Everyone left with a workable arrangement, and importantly, there was no dispute and no escalation. And finally, let me mention service apartment operator that was tied into an exclusive supply agreement for furniture, fixture, and equipment, which is known as FF&E, with a single international vendor. Shipping costs had tripled because of the global logistics disruptions, and the exclusivity clause prevented the operator from sourcing locally at far lower prices. We approached the international vendor directly, presented a detailed cost comparison, and proposed a temporary modification of the exclusivity clause to allow the operator to source FF&E from a UAE-based manufacturers while the international supply chain stabilized. The vendor agreed, understanding that flexibility in the short term would preserve the longer term relationship. It was resolved through a simple side letter amendment with no dispute and no adversarial process. So, what is the legal takeaway here? Under Article 272, you cannot simply cut off a supplier without formal notice and a reasonable cure period. Under Article 249, if an exceptional circumstances have made supply costs unreasonable, those terms can be rebalanced and negotiated. Consolidated purchasing, supplier tiering, renegotiated payment terms, and strategic use of local alternatives are practical tools that can work alongside the legal framework. If there's one message I really want you to take away from the today presentation, it is this: the biggest mistake is waiting too long in hospitality, and real estate timing is everything and very important. A hotel owner who approaches the operator early to restructure fees before any formal default has far more leverage than someone who waits until a breach notice arrives. So, when negotiations stall, mediation can be your best tool, especially in hospitality where relationships matter so much. It's faster than court, it's confidential, and it helps preserve the long term owner operator relationship that is often essential to the success of the property. I recently helped resolve a fee dispute between a hotel owner and an international operator through mediation in just 3 sessions. The financial details remained private, the brand relationship survived, and both parties walked away with a workable solution. If you compare that to years of litigation in open court with RevPAR figures and GOP margins potentially becoming part of the public record, the value of mediation becomes very clear. So let me bring all of this together by summarizing the practical solutions available. These include fee deferral, meaning the temporary suspension of base or incentive fees and their conversion into subordinated debt. They include KPIs adjustment so that performance thresholds reflect actual market conditions. They include budget restructuring, which means realigning operational and FF&E reserve budget to reduce owner capital injections. And they include payment rescheduling by negotiating new timelines for pre-opening expenses and operator-mandated upgrades. These are not just theoretical sides or ideas of that matters. These are strategies we have actually implemented for hotel owners, operators, real estate investors, and corporate operators across the UAE. Let me be very direct here. Doing nothing is the biggest risk you can take. If you stop performing your contractual obligations without formally initiating renegotiation or claiming relief, you expose yourself immediately to default. Liquidated damages begin to accumulate, late payment fees are triggered, and if your business involves multiple properties or multiple projects, cross default clauses can place your entire portfolio at risk. I advised one corporate real estate group that nearly lost three hotels' assets because single default in one property triggered cross default consequences under its financing agreements. So, this is not just because one contract, it can become much bigger very quickly. So, if you remember one thing from this session, let it be this. You don't need to break the contract, you need to rebalance it. UAE law gives you the tools to do that, including Article 249, mutual consent under Article 267, and the principle of good faith under Article 246 of the Civil Code. Whether you are a hotel owner, a real estate developer, or a corporate operator, the objective is the same: to adjust the terms so they reflect today's commercial reality while preserving the relationship for tomorrow. So, what should you do next? Here is the practical action plan. First, review your contracts carefully, including management agreements, lease, supplier contracts, and employment arrangement. Second, identify your pressure points. Where are the fees, the KPIs, or debt obligations that no longer make commercial sense? Third, start the conversation, whether this is with your operator, your landlord, or your business partners. And let me stress this point because it really matters. The earlier you act, the stronger your position will be. Every day you wait, your leverage decreases and your risk increases. Thank you very much for your time today. I hope this presentation has given you a clear picture of the legal tools available to you and the practical strategies you can start implementing right away. Whether the issues is a hotel management dispute, a commercial lease renegotiation, a supply chain challenge, or a corporate restructuring matter, we are here to help you to find the right legal and commercial strategy. Happy to discuss more. Please send me at m.darwish@darwishadvocates.com or reply directly to this email, and I will be sure to contact you regarding this. Thank you once again.